Sunday. And hello again from Fox News in Washington. The national debate over same-sex marriage took another turn this week when a federal judge ruled a voter-approved ban in California is unconstitutional. Ted Olson argued and won the case, which surprised a lot of people because he is a leading conservative lawyer who was Solicitor General under George W. Bush. Mr. Olson joins us now from Wisconsin. Mr. Olson, let's start with the issue of judicial activism. 7 million Californians voted for Proposition 8. 7 million people voted to amend the state constitution to ban same-sex marriage. Now a single judge overrules all of them?
Well, that's why we have judges. That's why we have an independent judiciary. We do not put the Bill of Rights to a vote. 41 states once prohibited interracial marriages, so that in Virginia, when the Supreme Court finally struck that prohibition down, the president's parents could not have been married. Our fundamental rights, part of our Constitution is a separation of powers and an independent judiciary. We ask judges to make sure that when we vote for something, we're not depriving minorities of their constitutional rights. And that's what the judge did.
But as a leading conservative lawyer, you have condemned such judicial activism in the past. Let's take a look at what you said in 2007. Judges have taken some of those decisions off the policy table, taking them away from the people by constitutionalizing these issues. Question, isn't that exactly what Judge Walker did in this case?
No, as a matter of fact, since 1888, the United States Supreme Court has 14 times decided and articulated that the right to marriage is a fundamental right. We're not talking about a new right here. We're talking about whether a fundamental right, something that the Supreme Court has characterized as the most fundamental relationship we have in this country, can be deprived of certain individuals because of the color of their skin or because of their sexual orientation. We do not permit discrimination, inequality. That's why we have a 14th Amendment that guarantees equal rights to all citizens. It's not judicial activism when judges do what the Constitution requires them to do and they follow the precedent of previous decisions of the Supreme Court.
But Mr. Olson, you have also said this: judges should, quote, interpret the law, not make it up, not create new rights that weren't there in the Constitution. Where is the right to, you've talked about the right to marriage, where is the right to same-sex marriage in the Constitution?
Where is the right to interracial marriage in the Constitution, Chris? The Supreme Court has said that marriage, the right to marry a person of your choice, is a part of liberty, privacy, association, and spirituality guaranteed to each individual under the Constitution. When you say same-sex marriage, you're saying a particular type of marriage. The Supreme Court has looked at marriage and has said that the right to marry is a fundamental right for all citizens. So you call it interracial marriage and then you could prohibit it? No, the Supreme Court has said no. The same thing here. The judge, after hearing 3 weeks of testimony and a full day of closing arguments and listening to experts from all over the world, concluded that the denial of the right to marry to these individuals in California hurt them and did not advance the cause of opposite-sex marriage. This is what judges are expected to do. It is not judicial activism. It is judicial responsibility in its classic sense.
So society doesn't get to say that marriage should be between a man and a woman, even though society has said that for thousands of years. 7 million people in California don't get to say that marriage is between a man and a woman, even though just November of 2008, 7 million Californians voted that they wanted to change their own state constitution to say just that.
In the 1960s, an equivalent number, is a smaller number, but of Californians voted to change their constitution to say that you could discriminate on the basis of race in the sale of your home. The United States Supreme Court struck that down. If 7 million Californians were to decide that we should have separate but equal schools, or that we would send some of our citizens to separate drinking fountains, or have them be in the back of the bus, that would be unconstitutional. If we didn't have a separation of powers, if we didn't have a Bill of Rights then 7 million Californians could take away your rights or my rights or the rights of these citizens in California. But we do have a Bill of Rights, and it's intended to protect us. The 14th Amendment was the result that the 14th Amendment that guarantees due process and equal protection to all citizens, to all persons, was the result of a civil war intended to enforce the promise of our Constitution that all men and women are created equal. The judge is simply fulfilling that promise, that American promise. The leading expert on the other side said that when we stop this discrimination, America would be more true to its ideals. That's exactly what happened here.
When new Supreme Court Justice Elena Kagan was up for Solicitor General last year, she said this, Mr. Olson: there is no federal constitutional right to same-sex marriage. Was now Justice Kagan wrong at that time?
Well, what she was expressing is that the issue had never come before the Supreme Court. The Supreme Court had never decided that question, and she was correct that the Supreme Court has not addressed that question. The Supreme Court will address that question at some day in the future, probably in this case.
But Mr. Olson,
she will have an opportunity.
You certainly are against judicial activism. How do you define what is judicial activism and what isn't?
Well, most people use the term judicial activism to explain decisions that they don't like.
Exactly.
What the court has done here... I'm sorry if I interrupted you.
No, I just said exactly. That's
yes.
How most people do define it.
Yes, and what the court decided here, the Supreme Court, as I said, of the United States, has 14 times decided that the fundamental right to marry is an important constitutional right. The judge applied that right, that existing right, that fully determined and repeatedly determined constitutional right, to some tens of thousands of citizens in California who are being harmed by discrimination. That is not judicial activism, that is judicial responsibility.